In this case, a juvenile was brought in for voluntary police questioning but was not read his Miranda rights. The juvenile admitted his participation in a crime and was later convicted. He appealed the conviction and the appeals court reversed, holding that the trial court erred by failing to consider the juvenile's age in determining whether or not the interrogation was custodial. The case then went to the U.S. Supreme Court. How would you decide this case? If a minor is called in for voluntary police questioning, should age be considered in determining whether it is a custodial interrogation, requiring the police read the juvenile his rights before questioning begins? We'll be back in a moment with the answer to that question. If a minor is called in for voluntary police questioning, should age be a factor in determining whether it is considered a custodial interrogation, requiring the police to read the juvenile his rights before questioning begins? No, according to the United States Supreme Court in this recent opinion. According to the court, no previous opinions applying the Miranda custody test have mentioned a suspect's age and experience, much less mandated its consideration when determining if an interrogation is custodial. Failing to consider the juvenile's subjective characteristics, such as age, was not an unreasonable application of federal law, held the court. This case involves Miranda warnings. A subject must be read their rights pursuant to the guidelines set forth in Miranda v. Arizona before a custodial interrogation can begin. Miranda rights must only be read if the person being questioned is in police custody and the police wish to question them, regardless of age. A person is in custody when they are subjected to either formal arrest or its functional equivalent. In this case, the juvenile was not formally arrested. He was being questioned voluntarily by the police. The Miranda warning was not required. The juvenile's age has nothing to do with it. Remember, it's a matter of law.